live. It is Friday, December 12th, 2025. It is 4:04 p.m. in Washington, D.C., and you are watching Lawfare Live, our weekly roundup of all the mishigas that takes place in United States federal courts and elsewhere involving litigation over the Trump trials and tribulations. I'm Benjamin Wittes, editor-in-chief of Lawfare, and I am here with not one, not two, but three Lawfare senior editors, Anna Bauer, Eric Columbus, and Molly Roberts, and one, count her, Lawfare Public Service Fellow, Loren Voss. Hello, all.
Hello.
It is great to see you guys. And before we get started, I have a confession, which is we had some technical glitches going into today's show. And as a result, I did not really get a chance to look at the planning document. So I want to apologize in advance for the comparative disorganization I'm going to display on this show. I am usually the living picture of organization in running these things, but not today. We're going to start with Anna Bauer because it has been quite a week in matters related to cases that you used to follow on a daily basis. We're going to start with the action in the JGG case, Anna, in Judge Boasberg's court. Anna, get us started.
Yeah, I love the chaos of this. This is incredible.
Putting the live in Lawfare Live.
It matches the chaos of the litigation this week, especially over the past 24 hours, where there's just been so many developments in these cases. For JGG, as Ben was saying, for those who don't remember, this is the case before Judge Boasberg in DC that involved the Alien Enemies Act planes that Judge Boasberg said, Drew Ensign, make sure that those planes, if they're already in the air, they're returned to the United States. And then he issued a written order to that effect. Planes took off anyway and continued on to El Salvador after stopping in a third country at one point. And Judge Boasberg, initiated contempt proceedings. There was a whole appeal up to the DC Circuit that then went en banc. Eventually, it came back to Judge Boasberg to continue his probable cause proceedings. And as a result, this week, Judge Boasberg this week ordered that Drew Ensign and also Rez Ruvini, who's a former DOJ employee who is now a whistleblower who's come forward with a number of allegations regarding what happened related to this litigation. Both of those folks were ordered to testify on Monday and Tuesday of this coming week. That then set off a race by the government to try to put a stop to this testimony. So first they asked Judge Boasberg to stay the testimony and also to reconsider his order, basically saying, this is inappropriate. You don't have the power to initiate this kind of fact-finding proceeding, those kinds of things. And Judge Boasberg said, no, actually, I want to move forward with this. I want to look at this question of willfulness because I'd asked the government to identify the decision makers and set forth some facts in these declarations, and I didn't really get much of a response because everyone who filed a declaration basically just said, the most basic thing that they could, and then invoke attorney-client privilege. So he wants to move forward with this and denied the motion for reconsideration to put a stop to this testimony. Meanwhile, the government has now gone up to the DC Circuit seeking a writ of mandamus, which is a type of really extraordinary type of relief in which you can get an appeals court to kind of compel a district judge to do what they are required to do by law. Here, the government is basically arguing those same kinds of arguments that Judge Boasberg's order to compel this testimony is inappropriate. There's attorney-client privilege issues here. There's no further fact-finding that he needs to do. And then they also cite as well to one part of the original order on appeal before the three-judge panel where Judge Katsas, although not joined on this point by the two other judges, Judge Katsas said, as a matter of law, I don't think that it's possible that this could lead to a contempt prosecution because the order was too ambiguous regarding the return of the planes. So they say, as a matter of law, this shouldn't proceed. Makes all those arguments. So that is now on appeal. And we are waiting to see. I don't think we have yet an order on a stay, an administrative stay from the DC Circuit. I presume, though, that we will probably see one coming quite soon. Someone correct me if in real time we've had an order in the past, 30 minutes, the last time I checked. But that's what's happening now, Ben. So it's possible this testimony could go forward on Monday and Tuesday, which will be quite extraordinary. I plan to be there if it does. But it seems like right now we're kind of in this limbo where we're waiting to see what the DC Circuit's going to do. And I will add to that end that I believe the panel this month involves Judge Katsas and Judge Rao again, who last time expressed some, as I said, Katsas said this couldn't lead to contempt prosecution anyway, but Judge Rao also seemed to express some reservations about the way that Judge Boasberg was handling the whole saga. So we'll see what happens.
So we are so right now what's going on, other than my expelling members of the audience, is that Judge Boasberg is getting ready to hold these hearings. There's scheduled to be one Tuesday, but it could get stayed or mandamused at any time by the DC Circuit. Is that a fair summary?
That's a very fair summary, and I would expect that we're going to see at least an administrative stay while the DC Circuit considers this. If not, a kind of eventual longer, an order that actually either puts this off for a longer period of time or that says, but you can't compel these people to testify. So we'll see.
Right. So, speaking of cases that once were daily fare on this show or weekly fare and now are a little bit more occasional, there has been a lot of action in the Kilmar Abrego Garcia case, and at least the last time I checked, he was a free man. Is that still true?
As of right now, it seems that he is still a free man. And things are moving very quickly in this litigation as well right now. This is we're going to start with the Abrego Garcia civil case, because remember, there's two. There's the criminal case in Tennessee. There's also the civil case before Judge Xinis, which was, Abrego Garcia trying to get released from immigration detention, making a number of constitutional claims and other claims regarding why he should be released from ICE custody, which he's been in since he was released from criminal custody after he returned to the United States from El Salvador. And Judge Xinis, after a long process of, it was kind of like playing whack-a-mole in this case. Like, the government would say, oh, we plan to remove Abrego Garcia to this country, and then they would change which country they wanted to move him to, and so then Judge Xinis would have to have more factual find more fact finding on that. There would be additional motions and litigation over it. It all was very long and drawn out because of some of those issues. But Judge Xinis finally issued her ruling in which she said, I'm ordering Mr. Abrego Garcia to be immediately released. The first key reason why she orders his release, Ben, is because it turns out that there was never an order of removal for Abrego Garcia. So you might remember there's been this kind of whole issue over in some of these hearings that Judge Xinis has had. She's asked government counsel or counsel have asked the witnesses who have appeared, have you ever seen an order of removal for Mr. Abrego Garcia? And no one could cite to having seen one or whether there was one in his immigration file. And so as a result, she says, there is no order of removal. And so there's, no basis to continuing to hold him for removal, which is why the reason you've cited why you're holding him is because you want to remove him to a third country. So there's that. And then there's also a secondary kind of alternative basis, in which she said, even if there was an order of removal, there's still due process issues. And she cites to this Supreme Court case that we've talked about before, Zadvidas. Am I pronouncing that correctly? Hopefully.
I've always pronounced it Zadvidas, but
Zadvidas.
But my
Okay.
Lithuanian pronunciation is not known to be superb.
I've heard it pronounced Zawidas, so there's so many
Oh,
options.
Oh, okay. Well, I am real confused now. That's a thank you, Eric. So she cites to that case, and says, and in which it's basically the general gist of it is you can't indefinitely detain someone for removal if you're not taking, steps to actually remove them. And the court set out this kind of presumption of after you get past 6 months, there's a presumption that the detention is unreasonable and that kind of thing. So citing to that case that no one knows how to pronounce, so write in, folks, if you do know the correct pronunciation.
Particularly if you are or speak Lithuanian, since Mr. Zadvidas or Zadvitas or Zadvitas was Lithuanian, although he was stateless, if my memory of the case serves, which is why he could not be deported to anywhere. But he was Lithuanian by birth anyway.
Well, okay, thanks for the background, Ben. But citing to that case as a kind of alternative basis, Judge Xinis says, even if there is an order of removal, there would be due process issues, and he should be released. And so Abrego Garcia, sure enough, is released yesterday afternoon. Meanwhile, there are additional developments that happen within hours after his release. This order comes out in which Judge Xinis says there is no order of removal. And sure enough, an immigration judge then issues a new order that is titled as a notice of correction of a Scrivener's error, which is a kind of if there's some kind of error that's typos or technical errors in a ruling or an order, typically that's the kind of thing that you would issue to correct those errors. Here, what the immigration judge does is say, oh, back in 2019, this order of removal was accidentally omitted from Mr. Abrego Garcia's case. So this notice is to correct that error, and effective, October of 2019 or whenever it was the original immigration proceeding occurred, there's now an order of removal. And then the government asks Abrego Garcia to show up for supervision, immigration supervision, the next morning at 8 a.m. So this tips off counsel for Abrego to the idea that, they might try to re-detain Abrego Garcia during this immigration meeting the next morning, based on this kind of notice of correction that the immigration judge issues. So they go to court, say to Judge Xinis, we want a temporary restraining order to prevent his re-detention during this immigration meeting. And Judge Xinis grants it, sets a briefing schedule, says you can't re-detain him and remove him from the continental United States while this is proceeding. And Ben, I will also mention as well, it's been clear throughout this whole thing that Judge Xinis is just to the end of her rope in terms of the fact that the government is just doing so much gamesmanship here in terms of, seeming to mislead her, not providing any kind of, real factual basis for things, doing all types of different things that really seems to suggest that they're intentionally misleading the court. And she says exactly that.
Of course, a big theme before Judge Boasberg in JGG as well.
Right, exactly. And Judge Xinis, in the course of these orders that over the past few days, whether it's the, memorandum opinion about Abrego's habeas petition, whether it is her latest order about the issuing a temporary restraining order for his redetention, she over and over again makes the point of calling this kind of behavior out. At one point, for example, in the memorandum opinion that she issued yesterday for his release, she quite literally says that the government affirmatively misled the court because there was this whole thing with they claimed that Costa Rica would no longer accept Abrego Garcia, when in fact Costa Rica, an official for the government, came out and said, what are you talking about? We haven't changed. We would still accept Mr. Abrego Garcia. So she cites conduct like that. Over and over again, she is pointing to and developing this record of all the instances here that the government has just acted with a true, disregard for the court's authority.
And just to follow up on that, in the case of Judge Boasberg, we know what he wants this to lead to, right? He's got this contempt proceeding, and the relevant question is whether he will be allowed to go forward with it or not. In the case of Judge Xinis, I don't have a sense of what in her, in the Abrego Garcia matter, it's leading toward, if anything. Do you?
No, I don't. I mean, I think that part of the reason why she's raising these things has to do with the substance of the case, right? Because she's trying to point to the idea that the government at every turn, it's been trying to say it has some real intention or real plan for Abrego Garcia, and it's doing that because of what I raised earlier about Zedvitas regarding, you can't just kind of indefinitely detain someone without actually taking real steps to try to remove them. And so she's trying to show that all of these things were just kind of a shell game for, we want to try to give the court enough to keep him in detention, but it's not real. It's all a facade, right? So that's part of why she is specifically raising these issues. But I also, you're right. I don't know beyond that. Like, and I think that maybe there would have to be a motion for sanctions from the plaintiffs before she initiated anything like what Judge Boasberg has done. But here, the conduct of the government really does relate to the substance of Abrego Garcia's case, and so that's one reason why she's been raising these issues.
All right. So basically, status quo ante, Abrego is free until you get an alert on your phone that says he's been re-detained, and Judge Boasberg is holding a hearing on Tuesday until you get an alert from your phone that says the D.C. Circuit has slapped an administrative stay.
Right, exactly. And I will mention, look, the guy was sent to a gulag in El Salvador back in March. He then was brought back to the United States, put in criminal custody immediately, and then immediately went to, well, I think there was maybe one day gap, immediately then transferred to immigration detention. So this is the first time this man has been, really at home with his family after many months of being wrongfully deported to El Salvador. So it is a really remarkable development. We will keep watching it.
For however long it lasts.
Right. And there are also developments, though, in the criminal case that I think are worth mentioning.
Yeah, so let's talk about that. When last we touched base with the criminal case, there was an ongoing vindictive selective prosecution motion to dismiss, which I think was sort of the fourth most compelling of those motions ever filed in the history of the United States, after two or three others that were filed this year. What is the current? There was an order an order on discovery that found not probable cause, but I'm losing my words.
There's
Prima facie.
Well, yeah, there's
a prima facie case of
yes.
vindictiveness. So, and then there was a series of discovery disputes and then I kind of lost track of things. So where are we now?
Yeah, so Ben, there is an alternate universe somewhere in which I'd be sitting here having just come back from Nashville this week for a vindictive or selective prosecution evidentiary hearing, because the posture that we're at is Judge Crenshaw said, I feel like there's a prima facie case of vindictiveness, but that means what we do now is open up for an evidentiary hearing, and then the government has an opportunity to kind of rebut this presumption of vindictiveness. And as a result, we were supposed to have a hearing. Initially, the government said that the U.S. attorney himself, Robert McGuire, would testify, that an HSI agent who was on the case was supposed to testify. And then the defendant, Abrego Garcia, also was trying to compel Todd Blanche to testify. And there was a subsequent motion to quash. That's been pending. And then there was this discovery issue that has kind of taken place behind closed doors because a lot of the filings have been sealed. The defense said, the government has 3,000 pages of documents that they say they have, but they're attorney-client privileged. But we think that these things should be handed over to the defense or at least reviewed in camera. So the Judge Crenshaw said, okay, I'm going to have the government hand over these documents and I'll review them in chambers, and then I'll kind of rule on whether any of these need to be produced to the defense. So that was ongoing. Now we have this issue where it's like a bunch of this is happening under seal, so we're not really sure what's going on. But the most recent public happening related to it is Judge Crenshaw canceled the evidentiary hearing that was supposed to move forward. And then this week said, there are these 6 documents that I want the government to turn over to the defense, but we don't know what those documents are. There's still, it's still kind of confusing in terms of like, we don't really know what's going on, but the evidentiary hearing was canceled. It's not clear whether or when it will be rescheduled for.
All right. With that, let us turn to Eric Columbus to discuss the case of the awesomely named Faustino Pablo. And let's start with who he is. Who are we talking about here, and what is his case about?
So this is one to watch because it is very similar, sadly, to the facts of Mr. Abrego Garcia. Faustino Pablo is a Guatemalan citizen who came to the U.S. to seek asylum. He was apparently unsuccessful in getting any permanent any ability to remain in the United States, but he did win withholding of removal to Guatemala. He's under the immigration judge concluded that it was more likely than not that he would be tortured in Guatemala by the Guatemalan government or with its acquiescence if he was sent back there.
And why is that not per se a basis for asylum?
You are now have now exceeded my knowledge of.
Because I would think that the very definition of a valid asylum claim is if you are more likely than not to be tortured.
True, but we do have a third-party removal ability, which precisely was what we're seeing with Abrego Garcia, in that he cannot be sent back to El Salvador, but he could be sent to
somewhere else.
And he has suggested Costa Rica, but the government is like, no, that is not sufficiently sadistic for us. We want
Liberia.
Yeah. So Mr. Pablo won withholding of removal from Guatemala. He lived in California for a decade and would report to immigration officials periodically. On last month, November 5th, ICE detained him at a regular check-in appointment without any notice, apparently. And 2 weeks later, he was, or I think maybe 2.5 weeks later, he was deported to, guess where?
Guatemala?
Got it. And his lawyers are now trying to get him back. And the court, the government has been contesting the jurisdiction of the court, and the district court in the Western District of Texas, where Judge Guadarrama, who is an Obama appointee, basically rejected the arguments of the government and cited holdings in the Abrego Garcia case that basically sliced through kind of the Gordian knots of jurisdiction and said, we're not, even if there's no ability to challenge his detention, he can still challenge the, quote, blatant lawlessness of his removal. And the court ordered the government to facilitate his return, which I believe using the words that the Supreme Court had used in Abrego Garcia, by a deadline of today at 11:59 p.m. Mountain Standard Time.
And do we have any idea whether the government has taken any steps or plans to take any steps before midnight Mountain Time?
I have not seen any indication either way. So it will escalate if that does not happen by today.
All right. So here's a name we haven't heard in a while, Rameza Ozturk. And apparently there have been some developments in her case as well. She is, people will remember the Tufts student who she's Turkish and was uh, detained as a result of a op-ed that she may have, or she contributed to. She was one of, several authors on. What is the latest with her?
This is kind of a nice example of audience interaction in that this development came to my attention by reading an article, rather a post linking to an article written by, I believe, someone who I believe is listening right now, John Hawkinson, for Cambridge Day. He's been following this case and a lot of these cases quite closely. And as he reported, a district court in Massachusetts issued a preliminary injunction that required the government to restore her status in the federal Student and Exchange Visitor Information System database, which is known as SEVIS, which controls whether she's allowed to legally work in the United States. And the judge kind of tiptoed around the what I think for most of us would be kind of a thing of the heart of the issue, the First Amendment issues, challenges that she raised. The judge did not address those at all, but instead found her termination in the database was likely arbitrary and capricious because the government had been offering shifting explanations over the course of the litigation as to why she'd been terminated, as to how it was consistent with the fact that her visa was not in fact terminated, and it was all just very kind of chaotic on the part of the government, which somehow seems to reflect the manner in which they've approached so many of these I guess you call them ideological deportation cases, usually involving people who have advocated on behalf of Palestinians in regard to Israel's operations in Gaza. So the government is still trying to kick her out of the country, but for now she can resume her normal graduate work at Tufts University.
All right. So let us turn from the subject of people we are trying to deport and courts that are to people we are trying to put on the streets of the United States in uniform, either because they are domestic National Guard or because they are troops, regular troops. Loren Voss, we haven't heard from Judge Breyer in a while, but he's back.
Yes, he's back, and the thing that we've all been waiting for has finally happened, where all of the cases are starting to congeal into like a Frankenstein monster. But
Right, so this is
yeah,
the Los Angeles case and the Portland.
well, yeah. So he references both the Portland case because California National Guard have gone to Portland, and then he also references the Chicago case because we're waiting for the Supreme Court to tell us the meaning of regular forces. So it's all starting to, I mean, we're going to need a whiteboard next time, but it's all starting to come together.
And the whiteboard is going to look like, a paranoid, crazy person drawing connections between things.
That's how all my whiteboards look, but yes.
Not because you're actually crazy, just because it's that complicated.
It really is. I had a Word document, but it was like 20 pages, right? And at that point, it's hard to follow. So I think crazy, diagrams on whiteboards are the way to go. So yeah, so Judge
They also
Breyer.
make really good backgrounds.
Oh yes, okay. I could
one
make
in
that
back
happen.
of you and draw lines.
I have one that sticks to the wall. Yeah, okay.
Yeah, I think we can do that. It can be kind of your trademark.
I don't know if that's what I want. Yeah,
All
so
right.
Judge
So what,
Breyer.
what did Judge Breyer? What's going on in his court?
Yeah, okay, so to remind people, for Los Angeles, we had a TRO to stop the federalization of the California National Guard and return the control to California. Um, that was administratively stayed by the Ninth Circuit. That was the denial to rehear en banc. And then there was a hearing on 22 October. We're waiting to see what comes out of that. But then there was a separate district court injunction, right? And that was the one case that we have that's actually dealt with, like, what are the troops doing on the ground? And that was the one that said the troops can't take any action that violates the Posse Comitatus Act without a valid Posse Comitatus exception. Right. That was the one where they were doing things on the ground and they were like, oh, we heard that there's a presidential exception. That one was also administratively stayed by the Ninth Circuit. Newsom then tried to do a renewed motion for an injunction because there was a new federalization order. So the first one only went to August, so June to August. And so a new one came out in August trying to extend the California National Guard. Our last update on that was the Ninth Circuit panel saying, oh, well, we don't have jurisdiction over this. That should go back to the district court. We're only dealing with these other very narrow issues. So Judge Breyer put out his decision on that injunctive relief on the 10th. And it did start pulling all the cases together, right? So he first, the conclusion up front, he grants a preliminary injunction. So he enjoins the government from deploying members of the California National Guard in Los Angeles, and he directs them to return control of the California National Guard back to the governor. He stayed that until the 15th of December, Monday, so that the government can appeal. There's now 2 federalization orders that are at play in this case. And so we have the original federalization order and what we'll call federalization order number 2, which came out in August, and federalization order number 3, which came out in October. So basically the government keeps extending California National Guard. We're talking about 300 troops right now. So he's talking about both of these federalization orders and trying to assess them. And once again, we're back to 12406, really focused on that section 3, right? Unable with the regular forces to execute the laws of the United States. Unlike some of the other situations, they didn't really make the danger of rebellion situation here. So the government, of course, argued that after the initial federalization, all the extensions of federalization orders are unreviewable forever, right? Like it's done. That is not what Judge Breyer decided. So he then walks through, he uses the Ninth Circuit meaning of unable, which is significantly impeded, but not actually unable. He does reference Judge Berzon's statement in the denial of the rehearing en banc, when he says unable should mean unable, and the statute doesn't say interference or significant impediments, but he is applying the appropriate Ninth Circuit meaning of significantly impeded. And remember here, the Ninth Circuit said that the standard that we're applying here is that the court can review the president's determination to ensure that it reflects a colorable assessment of the facts and the law within a range of honest judgment. But he points out that this provision in the statute is an is statement, not a was statement in 12406, right? So you have to show that the president is unable currently when the federalization order comes out.
Tense issue.
Yep, right.
It reflects current conditions, not that at some point in Portland, things really might have sucked.
Yeah, right. And so this makes it very helpful that there are specific federalization orders in these number 2 and number 3 to look at. So he can point to these specific points in time. He says you can talk about past events, but you have to link that past event to your present inability to execute the law. And that risk is not enough, especially when the argument is that people are peacefully exercising a fundamental right to protest, right? And so there may be a risk of people getting violent in any protest, but that doesn't justify the federal use of military forces. And it's subsection 3, the one we're talking about here, is unlike 1 and 2 in 12406, where it doesn't include a danger. There's a danger of invasion or rebellion, but there is no danger of being unable to execute the laws. So it is current tense and what's going on right now. He actually says that the government's assertion that there's an inability to execute the law that remains in California is not only unsupported, but it actually borders on a misrepresentation. So he is pretty harsh on the facts as they present themselves. So we have the August 5th order,
Going all
and
Judge
he said,
Xinis on them.
right? So on August 5th, he's like, the most recent violent event was July 10th. It was 50 miles away and a crowd threw rocks. For the October 16th order, it's even more more removed from that original unrest in June. And that there was 2 incidents in October. A gang member threatened a federal law enforcement agent at a federal building. He did not escalate, and then he left, so it didn't actually turn violent. And then another protester shined a high-power laser into a federal officer's eyes. But he says the test is not a threat to individual officers. It's whether the president is unable to execute the laws, right? So those are, individual threats. And that the October order that refederalized the National Guard for those 300 troops actually, as part of that same order, took 200 of those troops and immediately said they were going to Oregon. Granted, they were already deployed to Oregon, just not on the ground. But that order was already showing, the argument is that 200 of those were not imminently needed to enforce the law in California. And then he points out that, Judge Immergut held that the events in Oregon did not justify the deployment of National Guard. So he points to both what's happening on the ground in California and what's happening in Oregon for that third order. He walks through the unable with regular forces. This is when we get to pull in what's happening at the Supreme Court in Illinois. He's now decided that after a review of the materials, that regular forces means regular forces of the military. He was persuaded by Marty Lederman's arguments, but he is waiting for SCOTUS to determine the meaning of that phrase in the Illinois v. Trump case that's at them right now. So he says, I'm going to apply both meanings, the meaning I applied in the TRO, which was civilian law enforcement, and I'll apply the federal military provision. He says there's 7,300 members of the Army in California right now. Taking aside the issue of whether or not with the PCA they could deploy, he's sure that 7,000 Army people could deal with this. And then he also walks through that the civilian law enforcement could execute the laws too. So this kind of, though, gets back to the point that we talked about a couple weeks ago, because it's not just a question of changing circumstances on the ground in Los Angeles. It's also a question of how frequently you could challenge federalization based on changing facts, right? Could that be a weekly challenge? Whatever. So Breyer says if the exigency is over and the president refuses to relinquish control over a state's National Guard, the state can seek court review of whether the preconditions are still met, with all the appropriate deference as the Ninth Circuit has determined you should give to the president. But the limiting factor still isn't identified here. But Breyer says it's not the situation here, because in this situation, at least, he has new federalization orders. So he could focus on those versus an extended federalization period of service. But then what you could see is a long federalization order. So not a 60-day or 90-day, but you could see like a 1-year federalization order, and then this question continue to come up. And then you also just have the question of, can you federalize for one situation, like LA under 12406, and then redeploy to other locations? Because Breyer looks at this for the third order, where they're immediately moved. But actually, during the second order is when some of them were moved over. And there's a weird question of, could you federalize for one purpose, and then at some point during that federalization move elsewhere? He puts in the beginning of his opinion, what's happening here is the creation of a national police force by state troops. And that's what the president's creating. And so, that's not what anyone wants, but there's still some interesting legal questions on if you could find a reason to federalize them that was legal, but then move them after that point. And so we just don't have those facts in front of us right now. But so we are waiting for the government to appeal by Monday, and we'll see where it goes from there.
All right. Meanwhile, at the Ninth Circuit, in the Oregon case, we have an opinion from a name that will be a deep cut to some members of this audience, which is Judge Jay Bybee, who, of course, is most famous for being the at least titular author of the torture memos, which are more commonly associated with John Yoo, the Berkeley law professor, but actually bear the name of Jay Bybee when he was John Yu's boss as the head of OLC. He was subsequently confirmed to the Ninth Circuit, and now has raised questions about whether apparently if you apply, they could apply techniques understood to be torture by many without violating the law, but they might not be able to be deployed as in Portland at all. Is that fair? No, it's totally unfair, actually. But what did Jay Bybee do?
Yeah, so I was skeptical at first, but it's worth reading if people have the time. So remember here, this is the Oregon v. Trump case. In this case, the Ninth Circuit did agree to rehear it en banc. That was back in October. And so Bybee has written a statement in support of this en banc review, and so the order is now modified with the statement. Judge Tung also wrote one as well. So he said that it's not unprecedented to write like this. We were having a discussion of like, okay, well, when has this happened before? And his citation is to 5 examples in the last 50 years. And I'm not sure if there's more, but it might be that narrow. So he says a couple interesting things. So one is he's challenging the level of deference that's given to the president, the Ninth Circuit said. Remember this colorable assessment of the facts within range of honest judgment. But that's because he thinks it doesn't reflect the Constitution's allocation of authority over domestic violence between the states and the United States. And you're like, okay, where is this coming from? So he refers to it as...
When he says domestic violence here, we're not talking about battered spouses, right? We're talking about violence in the domestic, as in at home within the United States rather than overseas.
Yes. So, riots, insurrection, violent protests, the range of things that might occur. And so he refers to it as the domestic violence clause. Most of us probably know it better as the guarantee clause. But that's the United States shall guarantee to every state in the Union a republican form of government and shall protect each of them against invasion. The part that people don't talk about is the second part of that, which is, and on application of the legislature or the executive when the legislature cannot be convened against domestic violence. So he brings this up. And then obviously we have the militia clause, which we've talked about a couple times here, right? So, Congress has the power to provide for the calling forth of the militia for the 3 reasons: execute the laws of the Union, suppress insurrections, and repel invasions, right? And so we'd be talking about, not the repelling invasions, but the execute the law or suppress insurrections. So what Bybee is arguing is that the domestic violence clause is a limitation on the militia clause. So Congress can delegate this power to the president, but the president cannot act against domestic violence with the militia unless he has the approval of the state. So he does a historical review. When you guys hear that phrase, I hope that you were thinking the first thing that I was like, what does that mean for the Insurrection Act? Especially 252 and 253, which don't require state approval, and we've used a number of times. So he does a historical review, and he specifically talks. He goes all the way back. So you can read that portion. But to our conversation today, he talks about the 14th Amendment in the Insurrection Act during desegregation, and talks about that this is in response to direct and active resistance to federal law in defying federal desegregation orders at a public school. Right. So he says there's an exception for open subversion of federal law. So no state request is constitutionally required under the domestic violence clause because the source of the domestic violence was the state itself. So to clarify, he's saying the rule that he reads out of the domestic violence clause and the militia clause is that state governments must request assistance as a necessary precondition to have a federalized deployment of the militia in response to domestic disturbances. But the 14th Amendment is an exception to that rule. So if states are actively opposing or resisting the enforcement of the laws, in violence of either privacy and immunities, due process, or equal protection clauses, the federal government can deploy troops to execute the laws of the United States. But the specific quote that I found interesting is he says, the domestic violence clause provides no basis for objection when the states themselves are the source of or have acquiesced in the unrest. Right. And so there's some room there. And this has come up, in the Illinois case about is the local government impeding federal law enforcement? Are they, doing things to slow them down, stop them, purposely impede federal law? And so you could see an argument still being made on that basis. So there's an exception here. This is really novel, and I think people haven't had much time to think about it yet. And so we'll see where it goes. But he also does argue that at a minimum, courts should be able to review the president's decision, especially if the reasons are pretextual. But once again, we're talking about the standards on whether you can use troops, not on the how, right? And that will probably be more deferential if we get to the how part. And he has this 3-step burden shifting scheme. I won't walk through all of it now because I know we're a little bit short on time, but I'd say it is somewhat similar to what the Seventh Circuit has already done, right? The president has to say what precondition he's invoking and what the facts are. The state can try to show by a preponderance of evidence that factual precondition is not met. And if they can, then it's back to the president. And he has to say, I have the statutory and constitutional power to do this, right? And then the courts can consider do that from there. But he wants the courts to determine if there was a pretext for an unlawful purpose. And he says at a minimum, that's what needs to be done. I would argue that the Ninth Circuit standard already, which ends in, a range of honest judgment, should already include that. Was this pretextual? Was this, a decision in good faith? But I think he makes a fair point that you haven't really seen that analysis detailed in the opinions yet. So I think it's an important thing to flag, but I wouldn't say that it necessarily needs to change what the Ninth Circuit's standard is yet. So fascinating argument out there. I'm sure all the constitutional scholars are in a tizzy. And so we'll see what
the Marty Lederman argument. It just kind of opens up a new lens on the question.
Yeah.
And,
so,
makes it interesting.
The en banc review will obviously address this. So we'll see what happens.
All right. Let us turn to everybody's favorite part of the show, the unlawfully appointed U.S. attorney's part of the show. And we're going to start today with Lindsay Halligan, but we're going to do some Alina Haba in there. Anna Bauer, get us started. My friend Dan Richman has been litigating to get his stuff back. And by stuff, I mean, all the stuff that was on his computer when the FBI came and took it. And this could have significant implications for any effort to refile a case against Jim Comey. What is Dan up to, and is he getting any traction?
Yeah, he's definitely getting traction. So keep in mind, remember the context here. Years and years ago, the government was investigating a different set of predicate potential or alleged crimes. And as a result, Richmond's devices were seized and searched. Years later, now in relation to the James Comey matter, the government then researched and restarted rummaging through Richmond's materials again without getting a new warrant. That caused, in the Comey case, when it was still pending and before it was dismissed, the magistrate judge raised concerns that, this was all being done in violation of the Fourth Amendment. Case is dismissed. Richmond brings a Rule 41G motion for the return of his property. That is a rule under the Federal Rules of Criminal Procedure that allows someone who's aggrieved by an unlawful search and seizure to try to get their stuff back. There was some weird stuff going on in this case, Ben, because it's filed in D.C., and it goes to Judge Collar-Catelli. It's filed just before Thanksgiving. And the government, over a week goes by, and I think it's maybe over 10 days go by, and the government still has not even had anyone who's filed a notice of appearance in the case. So the judge doesn't know, it's clear by then. Richmond said he was going to file a motion for a TRO. The judge directed him to file one. He then files one. And still, there's no response from the government, and not even an attorney of record, really, that showed up in the case. So it seems like, it's kind of like, what's going on here? Why is there no response from the government? So what Judge Collar-Catelli goes ahead and does is enter a very narrow temporary restraining order. It seems like it's geared towards, encouraging the government to file a notice of appearance and actually respond to this thing, because they were dragging their feet. So she enters this order saying, I want you guys to segregate these materials, and then don't access them unless you seek an order from the court first. And then she tells them, get somebody to actually file a notice here, and let's get going on this. So the government does ultimately, in the past few days, has had some action and has filed a response. Interestingly, the people who are handling this, even though it's in DC, it's the people who are signing these filings. It's Lindsay Halligan, and then it's Robert McBride, who's her new first assistant over in EDVA, and it's Todd Blanche. Those are the people who are on the filings, and Halligan and McBride have also filed notices of appearance in the case. But they respond to Richmond's motion for a TRO. They also seek file a motion to dissolve the TRO that Judge Collar-Catelli did enter. And there's a few interesting things in this filing. So the gist of it is that they're saying, a court can't enjoin the government from pursuing a criminal prosecution, and a litigant like Dan Richmond can't use civil litigation to try to put a stop to the government's criminal investigation. The irony of that being, as you might remember, Trump himself used civil litigation to try to delay a federal prosecution or a federal criminal investigation. That, of course, being in the classified documents case when he went to Judge Cannon and asked for, an injunction to, put a stop to the government's investigation in that case, which he successfully delayed for several months until the 11th Circuit intervened. That was in a very different context, though, not under Rule 41G context. And also, Donald Trump was the target or the subject of that criminal investigation, whereas here, Dan Richmond is simply a witness. So he does not have, like a criminal defendant would, the ability to seek a remedy for his potential violation of his constitutional rights by a suppression motion. Instead, Rule 41G is supposed to be one of the mechanisms that a person who is the victim of an unlawful search or seizure can seek the return of their property and vindicate their privacy interests. And so that is exactly what Richmond kind of argues in his reply motion that was just filed, I believe it was yesterday. And I think it's a pretty compelling reply, in that, he kind of goes through all the different ways in which the government is portraying things in a way that don't really match up with kind of what's really going on here. They're trying to suggest that there's no harm to Richmond because it's not a harm to be a witness in a potential criminal prosecution. But the response to that is, well, no, the harm isn't being a witness. It's that there's an ongoing violation of Richmond's Fourth Amendment rights because they're going through his stuff without having lawful authority to do that. And they've held on to this stuff for years and then never, bothered to try to seek a new warrant or follow a lawful way to go through it. So where we're at now, Ben, is that this stuff, Richmond's filed his reply. The government has its motion to dissolve the temporary restraining order. They're claiming that this has hamstringed the Comey prosecution and their efforts to, potentially pursue a further indictment. And we will see what happens. We're waiting for the judge to issue a further order, or maybe there will be a hearing. There's not been a hearing set yet. But right now, there is an order that prevents the government from accessing those materials of Richmond's. And the government says it's complying with that order. So it seems that this really has potentially put a stop to efforts to reindict Comey. But that doesn't mean, of course, that the government, maybe this motion, this TRO is dissolved. Maybe the government seeks other ways to get those materials. Like we've talked before about how the government could try to go to an internet service provider or that kind of route from another party to try to get these materials. I don't know what the world of possibilities is in that regard, but it certainly seems like there are options for the government, and the question is just like, why aren't they using those options?
It may be because there aren't any available.
Yeah, that could be it too.
These are 8-year-old, 12-year-old communications. 9-year-old communications. And there's, I assume the provider for most of them is Google. And they just may not retain stuff that long in the absence of some reason to do it.
Right, that's possible. One other thing I wanted to mention as well that's interesting about this response from the government, for the first time, remember we've talked on here about how the timing of Richmond's employment as a FBI special government employee is very important in the Comey case. Because the only evidence that they've cited, I encourage people to go and look at the piece that I wrote on this, looking through some FOIA documents. But the bulk of their evidence that they've cited in their public filings seems to suggest that it all occurred after Richmond left the FBI as a special government employee. Here, for the first time in this filing, the government admits affirmatively that Richmond left the FBI in February of 2017. Of course, there's also reason to think maybe he wasn't ever technically reappointed after June of 2016. But putting that aside,
I'm going to have a little problem with that argument.
Yeah, it's just interesting because in the Comey prosecution itself, they never actually would put a date on the date that Richmond left. So here they finally admitted that he did affirmatively resign in February of 2017.
All right, just a quick matter. So a member of the audience suggests that the provider is Apple because the material was taken from a mirror of Dan's iPhone. I don't think that's entirely correct, because a lot of the communications in questions are Gmail communications. They may have been taken from the phone, but the provider, if you had to reproduce the electronic communications, the provider you would get them from is probably not Apple. It's probably the underlying Gmail accounts. In Comey's case, the Reinhold Niebuhr account, and in Dan's case, I assume the Columbia servers are probably Gmail servers. Most universities are. So the question of which device you got it from doesn't necessarily answer the question of which provider you would get it from today. All right, let's talk about Alina Haba, who has had a very bad week, Molly Roberts, and I'm feeling bad for her because the Third Circuit said she was not lawfully appointed as U.S. Attorney in New Jersey, and she has acknowledged that she's not going to be U.S. Attorney there. So what's the state of play, and what is her consolation prize?
Yes. So Alina Haba decided to step down. I can't say I feel quite as bad for her as you do, although she somewhat, well, I don't know whether it was mournfully or defiantly said in her statement, you can take the girl out of New Jersey, but you can't take New Jersey out of the girl.
Yeah, although I just want to say that there's an important element there that's missing, which is no one was trying to prevent her from being in New Jersey.
No, and I wonder if
like-
she's self-deported or whether she's just...
But it's really, the statement should have been, you can take the girl out of the U.S.
New Jersey U.S. Attorney's office, yeah.
in New Jersey, but you can't take. But that's not really what she said, and so I wonder if she quite got the point of her own joke.
Well, she also said somewhat more seriously in her statement that she was stepping down to protect the stability and integrity of the work of the prosecutors in her office, who were having a lot of trouble because judges were essentially slowing down all the businesses of courts there for fear that they wouldn't be able to proceed if she was still on the papers and was U.S. Attorney. So she stepped down. She's been replaced with not one, not two, but 3 different officials who are authorized to oversee various parts of the U.S. Attorney's Office. The idea probably being that way the Justice Department won't get into any trouble with judges for basically creating a U.S. attorney without the proper process, which is exactly what got them in trouble in the first place with Alina Haba. Her consolation prize is Pam Bondi has appointed her special attorney to the Attorney General, I think, and her area of jurisdiction is U.S. attorneys. And this is not a position that has, to my knowledge, and I think to anybody else's knowledge, existed previously in the Justice Department. So,
and just to be clear, the historical practice in the Justice Department is that the U.S. attorneys functionally report in case contexts to the Deputy Attorney General's office. In all administrative senses, they report to what's an office called the Executive Office for U.S. Attorneys. They do not report to any senior advisor to the Attorney General, and so it is utterly unclear, at least in an org chart sense, what this role is.
yes, yeah, and it's, kind of similar to the Ed Martin suddenly becoming in charge of the weaponization working group and also pardons and also mortgage fraud. So that's what's happening in New Jersey. All the 3 people who've replaced her have ties to her or to senior DOJ leadership. And it's kind of weird because at the same time, Pam Bondi is saying we are appealing this, even though Haba stepping down would seem to moot the case. And also,
probably not.
No? Okay.
Actually, this is an interesting question that I'm curious if any of you have thoughts on. My impression is that it would not moot the case if there may be some intention to reappoint her.
Okay.
if the government wins.
Well, it wouldn't. Wait, the Haba case though is the posture is that it's on a motion to it was on a motion to dismiss. Is that right? From one of the criminal defendants, to a motion to dismiss the indictment.
I believe that's right.
And so you would think it would still be if at the time that the indictment was brought, she was the U.S. attorney. I think there would still maybe, but then there'd be a ratification question of like if you get a validly appointed acting or U.S. attorney who then kind of like ratifies that. I don't know. There might be some weirdness there, but I would think
one question is whether the question is moot as to the viability of the indictment, right? Presumably the indictment now stands because she goes away and somebody else's name was on the thing, and so, but the government presumably, it has its own now interest in the thing that's beyond the indictments. It's do they get to have the appointment that they want to have? Yeah. And I would think if as long as the government could honestly tell the Supreme Court, if we win, we want Alina Haba to be the acting U.S. attorney or the interim U.S. attorney in New Jersey, I would think that would not be a moot question. But I would be, I guess there's a criminal procedure and residual standing question here that I've never thought through. But it's not obvious to me that it's moot.
Fair enough. No, that's interesting to me, and I'm trying to play Roger today and do not have the breadth and depth of knowledge, so he might have a better response to you than I have on that particular question. I also should add that there's been another U.S. attorney stepping down this week. It was the acting U.S. attorney for Delaware, Julianne Murray, who said she was following Alina Haba, and Delaware is in the jurisdiction of the Third Circuit as well. And she said, the people that think they've chased me away will soon find out they are mistaken. So this is going to the same idea that they're hoping to eventually win and put all these people back. Nobody had challenged her appointment in court, but she preempted it by stepping down, I think similarly because there was the possibility that it was going to cause issues in the courts there. So, and then of course there's the U.S. attorney in the Eastern District of Washington, whose fate is also somewhat uncertain because his interim term expired this week without any judicial action to extend him. He has a title change at the moment, first assistant and special attorney, so we'll see if that does the trick.
That saves the day.
Yeah.
All right, but let's talk about, so this is a really interesting question about how binding a district court opinion is where, because certainly Judge Curry's decision in the Letitia James and Jim Comey cases does not bind the Eastern District of Washington. And it also does not bind any other judge in the Eastern District of Virginia vis-a-vis Lindsay Halligan. And yet, if I were another judge in the Eastern District of Virginia, I might be a little miffed if I started seeing Lindsay Halligan's name on indictments, because though they are not defying Judge Curry's ruling in the Letitia James case or in the Jim Comey case, the Eastern District of Virginia did rule that she's not validly the U.S. attorney at all, and she is still on the website as the U.S. attorney, and she is still, as best as I know, hiring and firing people, and she's still putting her name on indictments in front of Judge Leonie Brinkema, who is not a judge that I would particularly want to piss off. So, is Judge Brinkema pissed off, and what has she had to say about the question?
Yeah, you initially said miffed, and I was going to say that's kind of a gentle word for it. I think pissed off describes it a little better. She's not the only judge either. She had issues. She was miffed and or pissed off. She's not the only one who has felt that way. The magistrate judge, William Fitzpatrick, who was on the Comey case, and Judge Michael Nachmanoff, who was presiding over the Comey case, and Magistrate Judge Lindsay Valla. All of these had issues and questioned the prosecutors before them about why Lindsay Halligan's name was still on court filings. William Fitzpatrick said it was simply not acceptable. Valla said that she was going to annotate new indictments with footnotes to acknowledge the ruling, but many of these other judges said, we're going to go ahead and we're going to strike her name from the ruling entirely. So it's been difficult, I think, also for the line prosecutors who are in these courtrooms having to answer to the judges because they didn't make this decision. And in some cases, certainly in Nachmanoff's case, the judges have expressed some sympathy for the prosecutors who are getting asked essentially impossible questions. And one of those prosecutors had to say, it's not something I've seen in my 35 years, but we're following the Office of Legal Counsel's guidance on this. It's not our decision, basically. And the guidance has been very confusing. So the Department of Justice, the U.S. Attorney's Office has reportedly sent at least 5 different internal guidance emails on how to sign filings in the district. And initially they said, remove Halligan's name, just list her number 2, the first assistant U.S. Attorney, Robin McBride, who Anna mentioned. And then they were told, never mind, list her first, then list McBride, then list Todd Brandt. So they're doing 3 now. And the Justice Department reportedly consulted the Office of Legal Counsel on the point, and the Office of Legal Counsel said it is fine to keep Lindsay Halligan's name on these filings, and it's fine for her to stay in office because the decision did not require a specific measure to be taken, like her removal. What else it possibly could have required, given the decision was that she was improperly...
dismissal of the indictment.
Okay, just a dismissal of the indictment, and then she can proceed.
And a case, a district court. I think the Justice Department is technically right about this. That it's just incredibly impolitic to play it this way. The motion was a motion to dismiss. The motion was granted because she was illegally appointed. It doesn't say anything about what else she's required to do. Now, if you were a smart administrator of the Justice Department, you might say, we're putting a lot at risk by having a person who is illegally appointed run the office and therefore it would be better not to have her do these things but the ruling does not require her removal from office. And I think it's sort of like technically correct to say you comply with it by dismissing the indictment. That's done. And now let's go on with the business of the office at the risk of infuriating the district bench.
So then what would the possible road forward be? And would it be for someone else to challenge her appointment and a new ruling to come saying she was improperly appointed and the remedy is for her to leave? What would it require for her to get out of there?
I think first of all, there comes a point, and it's probably when the circuit affirms the decision, when the position becomes untenable, which is what happened with Alina Haba.
Right.
And also you get a situation in which you could imagine, for example, personnel actions where somebody would sue and say, well, say you can't fire me or you can't promote him because you're not lawfully in the office, right? Once you have authority that you're not lawfully in the office, there's sort of these little, it becomes a problem and it becomes an administrative hassle to leave you there. But and one of the problems is that district judges get really pissed off and start asking questions. But I don't know that anything about that opinion requires that she be removed from the office. It just enhances legal risk of leaving her there.
Well, that is very clever of the Office of Legal Counsel then.
All right. Molly, what day of the week is it?
Friday.
And what does that mean that yesterday?
It means yesterday was Thursday. Yes, it does.
And what is a Thursday in the Eastern District of Virginia?
Thursday's grand jury day, and
it means it's try to indict Letitia James Day.
I was not nearly specific enough. I have a specificity problem too, I guess.
Yeah, so what happened yesterday?
They tried again to indict Letitia James. This time, they tried in Alexandria. They tried last week in Norfolk. It was the same guy, Roger Keller, not Lindsay Halligan, who went and tried to get the indictment. Perhaps they tried in Alexandria again, given that's where Lindsay Halligan had success in the first place after a grand jury hadn't shown much appetite for it when they were conducting the investigation in Norfolk. But again, they failed. And what does that say besides the case is terribly weak? Like I mentioned last week, it suggests that if you're not willing to play as fast and as loose with the grand jury process as Lindsay Halligan appears to have been, it's more difficult to get an indictment for a case as weak as this one evidently is. So I don't know, maybe they'll try again, but each time they try, it's fuel for selective and or vindictive prosecution motion if they ever manage to get a true bill. So they're not, the case, which is already obviously tremendously weak, is running into even more challenges, running itself into even more challenges every time they try and fail to get a grand jury to indict.
All right. We have two more subjects, and then we're going to wrap up. I'm going to ask people to let's use the chat only for questions right now, because I want to get to a couple audience questions, and we don't have a Q&A in this in this studio. Eric, we had a oral argument in Slaughter, the Humphreys executor's executor case, and it went about as badly as for the people who want Humphrey's executor to stick around as everybody expected it to. What do we need to know about this oral argument that isn't kind of hasn't been sort of hanging out there obviously since Seal of Law? Hang on, let me unmute you. There you go.
I will assume familiarity with the case for the purposes of time. And the question is whether the president can fire independent agency heads without cause, and thereby overturn Humphrey's executor, a 1935 decision that held that the president cannot do so, and that the Congress can create agencies somewhat insulated from presidential control, even though the president appoints the members, who then are subject to Senate confirmation. Basically, there wasn't much suspense going into oral argument. The only real question was how broad the opinion will be that overturns Humphrey's executor. And the justices were interested in the six who are going to vote to overturn Humphrey's executor. Some of them were interested in how they could write an opinion that avoids some of the more difficult questions down the road, and the dissenters to be were basically like, how can you possibly do this? How can we overturn Humphrey's executor without inevitably tipping our hand as to what will happen down the road? And the questions that lurk beyond whether or not the president can fire the head of an independent agency are questions about, for example, the independence of congressionally created courts, such as the tax court, the federal claims court, and then the next level is what needs to be done with what can be done with federal employees, with those who are both higher up with some policy-making functions, who are often known as inferior officers, and then the civil service more generally. Because if you take this notion of the unitary executive to its logical conclusion, which is that the entirety of the executive branch is vested within the person of the president, and that the power to, if the president therefore should have the power to remove every person who exercises executive authority, then it really leads to the demise of the nonpartisan civil service that we've had for about almost 150 years now. And the Solicitor General, John Sauer, kept saying, "Oh well, we're not challenging those things in this case." And Justice Kagan and Justice Sotomayor were like, "Well, sure, you're not challenging them yet. That's the next case. Just as this case, this slaughter case is kind of the culmination of a series of cases chipping away at for-cause removal protections. The inevitable next steps will be to make those challenges. Sauer would not kind of tip his hand, basically. He did say earlier this year the Supreme Court, in granting a stay of a district court opinion that tried to prevent Trump from firing members of the National Labor Relations Board and the Merit Systems Protection Board, the Supreme Court stuck in a sentence carving out the Federal Reserve as an exception. They said the Fed is a uniquely structured, quasi-private entity that follows in the distinct historical tradition of the first and second banks of the United States. And most people think that's kind of gobbledygook, and what the Supreme Court really meant is that they don't care as much about a president screwing up an independent agency, but they really care about the president screwing up the Fed. Because
it really reminds me of that Rehnquist decision where he distinguished, I forget which case, on the basis that that was a case about a big railroad. It's right.
And the Solicitor General was like, sure, we're fine with that exception. We're not challenging that exception. Kavanaugh mentioned it, and the Solicitor General was like, basically, you go ahead with your little crazy exemption there if you want. We can't do anything about it. We're not going to fight you here. So it's going to be a 6-3 decision, almost certainly, and Humphrey's executor will be executed. And I think the questions about what remains beyond that are not going to be resolved, with the exception of the Fed.
All right. Finally, last case we're going to talk about, Molly Reynolds. We have another group of FBI agents, 12 of them this time, I think, suing over their terminations. They are not principal officers. They're not agency heads. They're not quite civil service either. Their FBI agents are complicated animals, but they're not. They don't have no protection. So what's the what do we know about this FBI group of FBI agents and their claim?
Yep, they are special agents, and the story for them is that they were stationed in D.C. in the summer of 2020 during the mass protests that followed George Floyd's killing, and they were patrolling with firearms and vests, but this is what's in the complaint, but without sort of the requisite planning and training and protective gear, and crucially without less than lethal munitions. And so what they argue is that to avoid triggering violence in an instance where there were both violent protesters sort of cornering them up against the National Archives and a bunch of families, nonviolent protesters nearby, they kneeled in what was a de-escalation response. At the time, the FBI and DOJ leadership reviewed their actions and determined they were consistent with FBI policy. There was no adverse action that should be taken, and they thought they were all set. But then this year, Kash Patel triggered an internal review and fired the agents en masse. He had issued a request for the names of all the agents involved in the kneeling incident, and this was following them having gone viral around the time that this happened for kneeling, and on kind of right-wing social media. What they did was painted as political protests, as a left-wing act rather than just a neutral act to try to de-escalate, avoid violence, because they didn't have any way to subdue the crowd that wasn't lethal because of the gear that they'd been given. So that's essentially what has happened to them. The lawsuit says that the First Amendment prohibits government officials from dismissing public employees for partisan reasons, that political patronage, wherein public employees only keep their jobs if they support the favored political party, is unconstitutional. And it says this is also a Fifth Amendment due process violation. And there are protections in not the Civil Service Reform Act, which the FBI is actually exempt from, but in parallel FBI procedures. And then Congress has also provided some additional statutory protections for some FBI employees. Those are in senior executive service. So that's basically the story. I'm trying to keep it short. The forms that they got related to their removal said that the justification was just Article 2. And the idea here is that doesn't allow the government to violate the First and Fifth Amendments or rules set by Congress.
All right. So that is, by the way, the same justification as covered Maureen Comey, and interestingly tacks back to the point that Eric just made about slaughter, which is, the argument that you can fire a head of the FTC or an FTC commissioner, or for that matter, a Bank of the United States or Fed governor, is Article 2. And they are saying in the Supreme Court, we're not challenging civil service rules, but they're using the exact same argument to dismiss line agents and federal prosecutors. And so it is not hard to see where Kagan's question comes from. All right, speaking of questions, we have a few from the audience. We're going to go through them quickly. I'm going to read all the questions today, and I'm going to ask the people they are directed to be brief in answers. John Hawkinson, author of said article that Eric Columbus referred to, asks, are grand jurors supposed to not read the news in the way that pettit jurors aren't supposed to? So obviously this will vary from grand jury and jurisdiction to jurisdiction, depending on local rules and whatnot. Also, depending on whether the grand jury is a special grand jury that is focused on a particular thing, or whether it is a general grand jury that's hearing a lot of whatever prosecutors happen to bring. In the latter case, which is the overwhelming majority, no, you can't tell them don't read the news, because they don't know and you don't know what stuff they're going to you're going to bring before them, and they often sit for for rather protracted periods of time. And so just them being ambiently aware of what's going on in the world is part of the risk of having a grand. It's just part of having a grand jury. Lawrence asks, this is for Anna, why is Dan Richmond not making a bigger deal about Lindsay Halligan being on the filings in his case?
I don't know. I don't know. I don't know that there would be any reason strategically to make a big deal of it. Because in the cases where her appointment is being challenged, it's like you're seeking to show that something like an indictment must be dismissed or a subpoena must be quashed. You're trying to get something thrown out. Here, Richmond's trying to get his property back. So I don't know. I mean, maybe he'll mention it at some point. But I just strategically don't know what the kind of end goal would be, and why, it would, I would think, if anything, antagonizing Halligan over, the U.S. attorney thing, would be counterproductive in terms of, the litigation. So,
All right.
Ben, do you have thoughts on that?
I don't. My assumption is because the government can have any lawyer defend it it wants, and it doesn't really matter if she's the U.S. attorney or if she's Mickey Mouse. If they want to put her on the briefs in defense of something, I'm not sure that raises the same set of issues. David and Andrew ask, what could Judges Xinis and Boasberg actually do? Sorry, the chat just scrolled, and that made me lose my place. And now I am completely lost.
We do have an administrative stay, though, it looks like, from the DC Circuit related to JGG.
Okay.
So while you're
please
looking
stop adding to the chat because I need to read these questions now. What could they actually do with a ruling against the government and at large, or attorneys and federal officers in particular? And have there ever been sanctions against federal government lawyers? I guess that's also for Anna, given that both of those cases were in your.
Well, wait, sorry. The question was, the first part of the question.
What could they actually do against the lawyers and officials in question?
Right. Okay. So with JGG, I mean, there's two things. Judge Boasberg has already said in his previous order that his options are refer the contempt for the criminal contempt for prosecution, and then if the government does not prosecute it, then potentially appoint a prosecutor under the federal rules to appoint to actually pursue the prosecution. There was earlier, remember, this came up with the I think it was like the Eric Adams, Emil Bovee situation. There was this like question around what the authority is of a federal judge to appoint a kind of special prosecutor type of situation where the government declines to prosecute something. So I seem to remember some kind of question that came up in that, but it was a very long time ago. So I am a bit hazy on it. But here, that question could very well come up. So with respect to the criminal contempt, there's that. I mean, there's other types of sanctions that courts can, and in civil litigation, there's like Rule 11, and there's different types of sanctions in a civil context that don't involve criminal contempt of court, and just other types of conduct that courts can issue. And the second part of the question, have there been sanctions? Yes, there almost certainly.
That has happened
that has 100% happened. I don't have specific examples off the top of my head, but absolutely government attorneys have been sanctioned in the past.
And in fact, famously in the Indian Trust Fund case, Royce Lamberth held numerous cabinet secretaries in contempt.
And also did things like, what was it, like the internet connect?
He turned off the internet at the Interior.
He turned off the internet. Yeah, that was incredible.
Yeah, all right, we are going to leave it there, folks. It is, this has been a wild and woolly show for so many reasons, substantive and technical. Thank you, everybody, for sticking with us. And apologies to those who had trouble accessing it. And congratulations to everybody who got the extra bonus of watching audience members pop on screen and watching Anna Bauer and me be entirely flustered by it. We're going to be back next week. Folks, the trials and tribulations, as well as our tech trials and tribulations, will continue. Oh, and I think I have to stop this because nobody else can. Bye.